So, as mentioned, I'm a part of the team at Scott and Scott that is working very hard on the litigation against Tyson, JBS, National, and Cargill. Bill and his team thought it would be helpful for me just to provide you with a bit of an update on what's happened in the case since we last spoke last year, and a few other developments in relation to the government investigations. But before I got stuck in, I just wanted to take this opportunity to really thank Bill, his team, the board for all the help and support they've provided us in prosecuting this action. They have been incredible, always helping us for anything we need, be it, do you know a person who can speak to this issue? Can you get us that? Just really fantastic clients to work with, and it's really great for us to be involved. Similarly, big thanks to the other plaintiffs. I know a few of them are there with you all now. The Weinreich brothers, Eric Nelson, Rick Chambers, Jim Jensen, and Nate and Steve Graham, all doing a stand-up job, fighting, this small part of this greater cause. And, I think, it just couldn't be done without them. And, it's certainly great for us to be working with such great clients, and we really appreciate it. If we switch to the next slide, please. So, I'm conscious it's getting late in the day, so I will be relatively brief. I intend to give you guys an update on where we are at in the litigation, what's happening with the government investigations, shortly touch on what it is you can do to help, and then answer any questions that you might have, be it on anything I've spoken to or any other matter. You just have to feel free to ask. Go to the next slide as well, please. Wonderful. So, when we had last spoke, I think last August, what has happened since then, when we spoke in August, the case had been organised in Minnesota. It was pending before Chief Judge Thunheim. It remains before Chief Judge Thunheim. The defendants moved to dismiss our complaint in or around August, rather than file opposition papers. At that time, we decided, for various reasons, to file an amended complaint outlining some new and improved information that we had gathered in the gap between filing the initial complaint in April up to that point. So we filed an amended complaint, as we were allowed to do under the rules, in October. Unsurprisingly, the defendants moved to dismiss it again in November. What followed is typical in these cases is, both parties put in written submissions. Then there was a pause, and the judge heard oral arguments on the defendant's motion in June. The oral arguments, the impression from all of us went very well. Judge Thunheim keeps his cards very close to his chest. He's not an easy judge to read. We felt what few interventions he had and what few questions he asked of the attorney speaking boded well for us. At the end of the hearing, he took the case under advisement, which basically means he's going to go away and think about it. So we expect a decision from him at any day. It could come tomorrow, but equally, it could be a few months from now. He's on no particular timetable when he has to get that decision out. And while the case is waiting that decision, it is, to some extent, stuck is not the right word, but a lot of the discovery and all the other work which sort of follows all kicks off once he issues a decision, hopefully dismissing the defendant's motion. In the meantime, we have been doing work with the defendants and the court to get the case ready to start discovery as soon as that decision comes out, we have various motions before the magistrate and the court asking the court to order the defendants to provide us whatever it is that they're currently being made to provide to the DOJ. So we have a few more hearings lined up in September. So in short, at the moment, the sort of two parallel tracks are that we're waiting for the court to rule on the motion to dismiss, and in the meantime, we're getting as much done on discovery that we're allowed to get the case ready so that as soon as the court hopefully rules in our favour on the motion to dismiss, we can hit the ground running and really get stuck into discovery and push the case forward. The other update is that you'll recall when we spoke last year, or maybe you won't, you might well have drowned out my droning on from your memory, that there was a case brought on behalf of beef consumers about the same time we filed our claim. After the DOJ announced that it was investigating the packers, a few other class claims were filed, one on behalf of direct purchasers of beef. So this is a class claim on behalf of those who bought directly from the packers. So think your wholesalers, your further processors, and some large supermarkets who might purchase directly, your Walmarts and Costco's, etc. And then there is also another class claim brought on behalf of what's called commercial indirect purchasers. So those are, restaurants and the like who buy their beef from a Cisco or another processor. And so it's sort of at least one stage removed from the sale to the defendant. Those cases were filed in sort of June, July, they're very early stages. They are still being organised. They are also before Judge Thunheim, and they will, we expect, fall in behind our claim and sort of follow in its slipstream. This, as a development, is neither sort of surprising nor particularly problematic. It's not uncommon in cases where, the feeling in the community is that, the case has some merit, that people will file, similar copycat claims, on behalf of other people who they think might be affected. The theory in all of the claims on behalf of beef purchasers is that by, slowing down and controlling the amount of cattle that they bought and killed, the packers reduced the amount of beef they were producing and thus increased the price of beef. And that's the central theory that they are running on. That, in short, is where we are on the litigation at the present point. Eric, if you could switch to the next slide, please. I don't know how large this timeline is up on your screen, so I apologise if it's difficult to read. We are effectively, towards the end of the first bar. You'll see the second last box is the judge issues a decision on the motion to dismiss. As I sort of foreshadowed a moment ago, as soon as we get that, we move headlong into fact discovery. And that's when we get to take depositions of all the defendants' cattle buyers, their beef executives, field buyers, etc. They have to produce a lot of documents. We will produce documents, and we'll get to have a real good dig around to try to work out just exactly, what was done. And then once that is done, and discovery typically will take at least a year in cases this large, we then move on to the two motions that follow that. One is that we will make a motion for class certification, which is basically a request for the court to say, yes, this is a case that it makes sense to proceed on behalf of a class as a whole, as opposed to requiring people to bring their individual claims. And then the defendants and perhaps ourselves will also move for a summary judgment, which both sides will say, based on the facts, no reasonable jury could conclude other than for ourselves. Assuming we get both past those, the case then will move on a sort of a track towards getting prepared for trial. This all takes time, depending on potholes and depending on other things. I think if it were to run all the way to trial, we're still at least 2 years away from that, perhaps a little bit more. If we could jump to the next slide, please, Eric. We spoke about this last year, but it's worth just reminding you, because it's a common question we get, which is, what do I have to do to join the class? I don't want to miss out. The short story is you don't have to do anything at the moment. The way class actions work is that, we have defined, proposed a class of people on, who we propose to represent to the court. That class is, everyone who sold fed cattle to the defendants from 2015 onwards, on a basis that was by on negotiated, if you sold it on a grid or a formula contract, which incorporated the reported cash price for that region, that would be included. Likewise, if you're selling it on a contract pegged to the CME price, that's included as well, because of the way interrelationship between the CME and cash prices. What happens at, assuming we get past class certification or assuming there's a settlement, people within that class will get a notice delivered by mail, notifying them that, they're in the class, and it will give them an opportunity to opt out, stay in. Assuming there's a settlement, they'll get notice again, or assuming there's a judgment, they'll get notice again, asking them to submit a proof of claim. Basically, it will be a short document saying, provide some evidence of how much cattle you sold during this period, and then that will basically entitle the individual to a share of any money recovered. So in the meantime, all you need to do is make sure you're keeping a record of your cattle sales, and also your live cattle futures and options transactions. And if we're fortunate enough to recover, at that time you'll get a notice that will provide details of how to claim. And we will of course provide Bill and his team with notice that he will with information to let you know that it's happening and how you can do that and answer any questions people might have. Could you jump to the next slide, please, Eric? Government investigations. I'm sure, like everybody else, you have found it probably impossible to turn on the TV in the past, 4 or 5 months without hearing, about the attention being paid to your industry, and the interest from not just regulators but politicians across both sides of the fence at various levels of the government. I think it's fair to say that it's been fairly unprecedented, that the amount of attention the industry has got, which I think is great, and I think Bill and his team and the board have done a great job in both encouraging that and also capitalizing on that. So I think even outside the confines of this lawsuit, I think that the attention has been great. Eric, do you mind just flicking over to the next slide? So what we have in the cattle and beef markets is a few separate investigations sort of running alongside each other. You have the USDA's investigation into the Tyson Holcomb fire, which got expanded to cover, the price disruptions that were triggered by COVID. you have the Department of Justice's investigation, and you have investigations by various state attorney generals. Obviously, the USDA, issued its preliminary report a few weeks ago. No doubt, lots of you have read that. It seems fine for what it is, a purely factual description of how prices moved. We, like I suspect all of you, are waiting to see what the second portion of the report, which will detail whether or not they think there was violations of the Packers and Stockyards Act. I think that's the report we're all waiting on. The Department of Justice investigation, I think, is the more interesting. You would have seen that in about early June, it was reported in the press that the Department of Justice Civil Division issued what's called a civil investigative demand to each of Tyson, JBS, National, and Cargill. That's in effect a subpoena that requires them to document. We understand that they've already made, have already made productions in relation to that. From what we can share, for what we know, we think the department's investigation, certainly it predates the COVID crisis, but nonetheless that it's still in its early stages. It's very difficult to predict which way it will go, but we understand from the reports that they're very busy and working hard to try to get to grips with what's happening. And so I think that is a long overdue federal scrutiny of these markets. And I think, again, even if they don't come to an infringement finding, the attention being brought to bear is certainly helpful for both the industry and for our case. The state attorney generals from a number of cattle producing states are also investigating the market. Not uncommon with these types of things, they tend to work hand in hand with the Department of Justice Civil Division. So we understand some coordination going there, and we know that there is a lot of political will amongst all the state attorneys general on both sides of the aisle, again, across all the cattle producing states, to take a really serious look at that. So, we are quietly confident that these teams are being staffed with the right people and throwing the right resources at it, that, this might be, a really productive and helpful thing for the industry. Again, these investigations take time. I think it would be probably unreasonable to expect that they'll come out with a finding in relation to their investigation this year. By normal timeline, even if they were to, move very quickly and have a lot of success, I wouldn't expect anything till midway through next year at the earliest. These things take time. The regulators move very deliberately. So, I put that in the watch this space. As far as the impact for our litigation, these things, these government investigations, when they're investigating the same conduct you're alleging, typically lend a lot of credence to your allegations. That certainly helps the court frame, how serious the conduct is. So it's certainly helpful for us in that regard. And certainly if you're a defendant, typically if you're facing both credible government investigations and credible civil litigation, that sometimes, creates more pressure to come to the settlement table and, resolve these types of claims. It remains to be seen how that will play out here. The other notable government investigations, which I'm sure you've also heard of, is what the Department of Justice's criminal division has been doing in relation to the broilers market. You might have known that's something they've been investigating since about 2017. and they recently indicted some Pilgrim's Pride executives along with some Claxton's Farms executives for a price-fixing conspiracy that concerned the price of broiler chickens. And it has also recently emerged that Tyson is what is called the immunity applicant in that case. And that basically means that Tyson was the first person to fess up to the Department of Justice that its employees were involved in anti-competitive conduct in the broiler market. And that what that triggers is, in exchange for blowing the whistle and cooperating with the DOJ, so long as Tyson continues to cooperate with the DOJ, it gets immunity from criminal fines in that case. One of the very helpful things for us, and where this relates to our case, the obligation to cooperate with the DOJ is not just limited to the chicken case, but if Tyson has been engaged in any other anti-competitive conduct in any of its other protein business lines, it's also obliged to tell the DOJ about that. So we would expect the DOJ is asking them some fairly searching questions about their cattle and beef operations as we speak. So again, they're all helpful developments for our case. It's still too early to sort of predict how exactly they'll play out, but typically in these types of cases, having parallel regulatory actions tends to help with the outcome. It can occasionally slow you down, but typically it helps the outcome. Before I move to questions, I just wanted to, touch on, what it is you can do to help. The first thing, and this is very similar to what I said last year, so apologies for banging a broken record. The first is, as members of RCAF, no doubt occasionally you'll get requests for comment or requests for an interview from the press. I would continue to ask that you refer those on to Bill so that they can be dealt with appropriately. We need to continue to be careful about what we're saying in the press, what might be attributed back to RCAF and thrown back in its face in the litigation. And the other is, no doubt, you would have heard maybe perhaps from your state associations and from others, calls to, report any suspicious conduct or any knowledge you or others have of any anti-competitive conduct you've witnessed, you've seen, you've heard of, to the regulators. I know that the regulators that have put the call out there, we'd continue to ask that not only do you engage with the regulators, that you let Bill know and that you talk to us. Don't ever worry that what you think you have might be irrelevant or be not important enough. Often you never quite know how that one bit of information you have fits into the bigger picture. So, always pick up the phone to Bill and he'll put you in touch with us and we'll be happy to talk with you. And, the other thing I would say is, on a bigger, broader picture, and I'm sure you're all doing this, but just continue to lobby your representatives to support the Department of Justice and State AG investigations. It's important that those regulators are getting the support they need politically and the resources they need to prosecute these claims. So, by all means, please continue to get on the phone and to let them know how much you welcome the scrutiny being applied to the market and, how you hope that it continues. And with that, I'll open it up to questions. Eric, do you mind jumping to the next slide? And it's certainly okay if you have no questions.
They're getting some questions here. Hold on a second.
Too easy.
Hello? In terms of the class action lawsuit against the Packers, how far can we go back to show our losses?
Great question. So, what we have alleged presently is a class claim starting from January 1, 2015 through to the present. The court might trim that. That sometimes happens, but as a ballpark figure, your working assumption should probably be, if we have success, it will relate to a period of about January 15 through to at least to maybe up to the end of 2019. It's probably a good estimate. It might run a bit longer, might start a bit earlier, might be a bit shorter, but those are the years that the litigation concerns.
And just so people understand, those are just for the fed cattle industry?
Yes, the claim is limited to fat cattle, fed cattle. Yeah.
Other questions? Hold on, okay.
Yes, Patrick. Earlier this morning we had Dr. Diana Moss. She didn't give us much encouragement with the DOJ, and you're saying these parallel efforts of the government should help us. Can you refute her a little bit? She was kind of a downer.
Well, not having had the benefit of Dana Moss's presentation, I don't want to dispute her directly. I suspect was she talking, if she was talking in the context of merger enforcement and sort of enforcing the antitrust laws regarding consolidation. Look, I think perhaps a concern is warranted. The last little while, neither the FTC nor the DOJ have been zealously enforcing the antitrust laws regarding mergers. But the enforcement team in relation to what I'll call behavioral conduct, so breaches of the Sherman Act and sort of Section 1 as to cartels, typically once although in recent years the DOJ has perhaps started fewer investigations than it has under other administrations. The attorneys who run these investigations are typically career attorneys who, once assigned, are very competent and would do a very good job at chasing things down. So half the battle is always getting the investigation started, and once it's started, I think these people are, good lawyers, smart, want, have do a good job. So, I would carve that exception out from Diana's, no doubt, very thoughtful criticism.
I have a question. So, these lawsuits that you're involved with on behalf of RCAF, whether it pertain to antitrust with the Packers or other lawsuits, I guess, are you able to use the Equal Access to Justice Act on any of these?
We have pled the cases as a very clean breach of the Sherman Act allegation. So basically, Section 1 of the Sherman Act prohibits any agreement between competitors to fix prices or allocate the market amongst various things. So our litigation is a very simple allegation, which is the four defendants reached an agreement amongst themselves to depress the price of fed cattle. we have an ancillary claim which is under the Commodities Exchange Act, which says that same conduct harmed people who traded live cattle futures. So no, we haven't thought to bring a claim under the Act that you spoke of.
But, oh, I'm sorry. Excuse me. Thank you.
It was my understanding at the first of this, when this was kind of first initiated, that congressional people and things was getting this right over to the Department of Justice, and it looked like it was going to sail right through. Now I get the impression that it's just like any other government deal. It's going to be backed off and changed and mitigated. And what changed?
I must admit, I don't quite. The Department of Justice investigation, I think probably only the civil investigation only started. I mean, I don't know the exact start date. It only started at the end of last year, I suspect, or the beginning of this year. But I can say from having defended these in my former life, where I still acted for banks and other corporations before I saw the light and jumped across the side of the fence. These investigations take time, and it's not so much of a lack of will from the politicians. It's just there's a process to go through to collect all the evidence, to sort it, to properly analyze it, to bring the claim, to give the defendants a chance to defend it. And I wouldn't. Once the investigation has started, it kind of moves from the political arena and it's put in the hand of career attorneys, and they just take time. So I wouldn't, it's just obviously it's disheartening in that we all want quick action, but the nature of both litigation and investigations is unfortunately that they take some time, and I would which is why I would say, and as Bill would say, it's important to keep lobbying your politicians to, for legislative reform alongside of it. Litigation and investigations can only, play one part of fixing this deal. They're not a cure-all. They're just part of the overall solution that we've got to keep pushing.
Anyone else right quick have a question? Okay, hold on.
On the attorneys on the defendant side, are they international attorneys? And would that be a problem?
Look, they're some of them are from firms that have international offices, but they are, all locally admitted lawyers. But they're all good law firms, but they're the same law firms that we come up against, in most claims we file. It's not a problem for us. It's not dissimilar, but no, they're obviously well represented. But that's what we face day to day, and it's no different for us. The beauty of most litigation is that whilst having good lawyers can help you, most cases are won on the facts, provided you've got good, competent counsel on both sides, which I think is the case here. Typically, the side that has the better facts tends to win, and whilst it's early days, I think we're on the side with the better facts.
Okay, thank you.
Anyone else?
As far as these other claims and suits have been filed by I guess retailers and others, there's been 3 or 4 of them. Will they help or hinder, and where does our case stand? Is it going to be? It'll be heard first, probably before any of those others come up.
Look, great question. So I think the way I would look at it is big picture they're probably neutral. There is some without getting into the weeds, there's a bit of a dispute between the parties at the moment as to how these new cases will be managed alongside our cases. But, you know, I suspect that the court will be keen to sort of, you know, manage them, you know, in a sensible manner to the extent there's some overlap. But, you know, because we are on the different side of the fence, you know, we continue to expect and we're going to continue to push for, you know, for our case to be treated as a separate case and, you know, for us not to be hindered or dragged down by these other cases, which, you know, while similar, you know, are very much focused on the price of beef, whereas we are obviously very much focused on the price of fed cattle. So, you know, I suppose to answer your question, I think that their filings effectively are neutral. It's neither particularly helpful and it's certainly not harmful. And as to, you know, how it will impact the scheduling of our case, you know, I think it's probably not going to affect it too much. And the court's sort of considering whether or not it joins up part of the discovery work in our case with those cases. And that's some of the things that will be decided in September.
Anybody else got one more? Okay, one more. Thank you, sir.
Patrick, in our case, we're having trouble with our state congressional delegation getting on board, helping with this Packer issue. You've mentioned the state attorney generals. Would they be the logical one from the state to look to get maybe get some help? And other than them, any suggestions where else we should go?
Yeah, great question. No, I think, you know, I can't think off the top of my head any of the state attorney generals from a cattle producing state that aren't on board with the investigations. So I think if you're, you know, struggling to get, you know, something going with the state representatives, they're probably an obvious place to pick up the phone to and say, you know, and even to, not only to A, express your support for what they're doing, but B, to perhaps ask for, you know, the inside baseball as to what's happening at the state level and who might be a good person to contact. I think that's probably a very good idea. I know the Nebraska AGs are interested in it. Absolutely.
Well, Patrick, thank you so very, very much for sharing that with us. Thank you for your work. Thank you for your diligence, and thank you for your passion in this issue. We appreciate it very much.
It's our absolute pleasure, and I'm sorry I can't join you all for a drink this evening. I hope you have a wonderful convention and a safe trip home.
You win this case, we'll buy you one.
That's fair. I'll hold you to it.
Please do.